Good afternoon. I am Arevalo, the reporter of Partnership versus Co-Ownership and Effects of Unlawful Partnership. Let's define first partnership and co-ownership. Partnership is defined as a situations whereby two or more persons bound themselves together to contribute money, property, or industry to a common fund with the intentions of dividing the profits among themselves. Always remember that the last part was important, the intentions of dividing the profits. Kasi kung wala ito, hindi natin matatawag na partnership at malamang baka ito ay maging ordinary co-ownership. Because co-ownership defined as owning a property by two or more persons. Let's give an example for you to understand. Si Brian at si James ay nagkasundo. Sabi ni Brian kay James, gusto ko magtinda ng fishball kaso lang wala akong puhunan. Sabi naman ni James, sige walang problema, bibigyan kita ng 10,000 para sa pambili mo ng kariton sa mga pangluto na sa mga raw materials na kailangan mo para sa pagtitinda ng fishball. Pero, hati tayo sa kita. So, ayun yung napagkasunduan nila. Kaya sabi naman ni Brian, sige, ako nang bahala magtinda. Basta sagot mo lahat ng mga kakailanganin ko. So, nagkaroon sila ng contributions. Si James, yung na-contribute niya ay yung pagbibigay niya ng 10,000 yung pera at yung pagbili niya ng mga raw materials. Si Brian naman, ang na-contribute niya ay ang industry, yung kakayahan niya at talento at kasipagan sa pagtitinda. So, ano yung purpose nila? Ay yung hatiin yung pera sa pagitan nilang dalawa. Ito po yung tinatawag natin na partnership. Ano naman yung co-ownership? Halimbawa, sabi ni Brian, James, gusto ko sana bumili ng kariton para sa pagtitinda ko ng fishball. Sabi ni James, o sige, hati tayo sa pera. Pero yung kariton na bibilin mo, hati tayong dalawa. Ibig sabihin, tayong dalawang magmamay-ari ng kariton na yan. So, yan po yung co-ownership. Ibig sabihin, yung kariton na bibili nila ay pagmamay-ari ni Brian at ni James. So, kung halimbawa naman po na lumipas na yung matagal na panahon at napag-isipan nilang dalawa na ibenta na yung kariton at kumita sila doon na halimbawa 1,000 at pinaghatian nila yon, hindi natin matatawag na partnership. Nung binili nila yung property, wala po silang intentions na i-divide yung profits nila. Kaya matatawag natin ito na ordinary co-ownership. So, this is the definitions of partnership and co-ownership. Let's proceed to the differences between partnership and co-ownership. As you can see on the creation, partnership was created by contract, while co-ownership was created by contract and law. Means that the more legal in these two is the co-ownership. In the juridical personality, partnership was legal or juridical personality, thus it can be sued or be sued. Meaning, yung partners pwedeng mahuli or makulong lalo kapag may utang yung partnership. Sila yung accountable doon. While co-ownership has no juridical personality, thus it cannot sue or be sued. Means na hindi pwede habulin yung mga investor kapag may utang sila. Pwede lang sila mag-file ng bankruptcy pero bawal sila makulong. In purpose, as I've said earlier, the partnership is all about profit. Kumpara sa co-ownership na sa property and rights lang sila mas nagpo-focus. For profit naman, yung sa partnership ay stipulated upon. Ibig sabihin, may mga plans or schedules na sila on how they will going to distribute their profits, kung kailan sila makakakuha ng hati. Sa co-ownership naman ay nakadepende lamang kung sino ang may pinakamalaki ang shares mula sa mga mabababa. In the dissolution, sa partnership, it is dissolved by death or incapacity of a partner. So, yung partnership pwedeng ma-dissolve once may namatay na partner. What do you mean by dissolve? Ito yung mawawala na, nalugi na, or stop na sa pagpapatakbo ng isang business. At kahit isa lang sa partners ang mawala, lalo na kung ito yung may pinakamalaking ambag, ay madidissolve talaga yung business na yon. But in co-ownership, it is not dissolved by the death or incapacity of co-owner kasi need ng grant ng estate bago ito madissolve. For form, partnership may appear in any form. Ibig sabihin, ang agreement lang na mapag-uusapan ay pwede na. Pero kung merong magbigay ng malaking ambag sa estate ay kinakailangan nilang ng public instrument para mas mabilis mapabisa ang partnership. Compared to co-ownership, they don't need anything even if it has real property contributed. In partnership, hindi basta-basta. May mga bagay rin na kailangan nilang pagtuunan ng pansin para literal silang matawag na partnership. Talking about profit according to rule number 3, the sharing of gross returns does not of itself establish a partnership. Meaning, hindi matatawag na partnership kung ang pinaghahatian nila ay gross return or net loss. Kasi kung ganun lang din, ay parang wala lang rin yung mga nasimulan nila. They need to maintain net profit on their business for them to be considered as partnership. For example, if the gross profit is 50,000 and the expense is 20,000, then there is a net profit of 30,000. However, if the gross profit remains at 50,000 and the expense amounts to 60,000, then there is a net loss of 10,000. Kaya as a result dito, we can't establish it as a partnership dahil nga net loss yung kinalabasan. Let's go now to rule number 4. The receipt by a person of a share of the profits of a business is prima facie evidence that he is a partner in the business. A prima facie case is the establishment of a legally required rebuttable presumption. It is a cause of action or defense that is sufficiently established by a party's evidence to justify a verdict in his or her favor, provided such evidence is not rebutted by the other party. Tumutukoy rin ito sa isang demanda o pag-uusig sa kriminal kung saan ang katibayan bago ang paglilitis ay sapat para mapatunayan ng kaso maliban kung may malaking salungat na katibayan na ipinakita sa paglilitis. Yung isang kaso ng prima facie na ipinakita sa isang grand jury or sa korte ng pag-uusig ay magreresulta ito ng isang pagsusumbong. It is evident that an isolated transaction whereby two or more persons contribute funds to buy certain real estate for profit in the absence of other circumstances showing a contrary intention cannot be considered a partnership. Isolated transaction means a transaction or event in which tangible personal property or a taxable service is sold, transferred, offered for sale, or delivered by the owner or by his representative. Uulitin ko, ang isang malinaw na isolated transaction kung saan yung dalawa o higit pang mga tao ay nag-aambagan ng mga pondo para bumili ng ilang mga real estate para lalo pa silang kumita. Ito yung nagpapakita ng isang salungat na hangarin na hindi maaaring isaalang-alang natin bilang isang partnership. Yung mga tao na nakapag-contribute ng mga properties o pera at pumapayag na i-share yung gross returns sa kanilang contribution ay hindi natin tinatawag na partnership dahil nagre-result ito na wala silang common stock and capital sa isang business. Gaya nga ng sabi ko, hindi pwedeng makonsider natin yung gross return as a partnership kasi nagre-result na rin ito bilang net loss sa isang business or company. Ibig sabihin, parang yun nga, wala lang din yung mga pinaghirapan yung mga na-contribute ng iba. Wala rin nababalik sa kanila, wala rin nadadagdag. Kaya, hindi talaga natin ito matatawag na partnership. The common ownership of property does not itself create a partnership between the owners. Yung pagkakaintindi ko lang dito, yung isang nagpapatakbo ng business ay hindi pwede makipag-partnership sa isa ring nagpapatakbo ng business. For example ako, meron akong isang business, tapos yung kaibigan ko meron din. Gusto kong makipag-partnership sa kanya, kaso nga lang, hindi yun po pwede kasi nga, parehas kami nagmamayari ng isang business.